our motions today, one of the alternates is having a difficult time, which I certainly understand. But I really don't know how to handle it. I'm thinking about asking the 12 when they get in here how they're all feeling. If they're feeling okay, and I'm thinking about just letting the two alternates go. But I know there's a risk. Or I can talk to the two alternates about their issue. One of them saying that the way we picked the alternates was rigged, which is kind of funny, but that's kind of what I'm saying. Then I gone back in the back and picked them. At first they were going to be, even though you saw me pull them out up here, but that's just today's environment. So I don't really want him on the jury. If somebody gets off, I'll do what y'all think. Basically what I was thinking was lecturing for a minute about how inappropriate that is. And second, saying, but if any of y'all don't feel like you can do this, and here's the risk, if I lose somebody, you gotta do it again. And all these people spend hours and hours working on this, but if y'all don't feel comfortable, because we may not get done today, they might have to spend another night. And I think he told one of the police officers he wouldn't stay another night, he was gonna go home. So, State got any feelings about it at all?
I have a lot of feelings, Judge. But it's not something, of course, that we deal with
Right.
regularly, and we want to do everything on the up and up, but we can't just assume that everything will be okay on it.
I mean, it's a very difficult job, you know. It's probably the hardest job of anybody here. And I recognize that, but still.
I'm definitely not unsympathetic to the situation they're in. That would be difficult. But I think perhaps maybe the lecture is appropriate because I don't think we can take a risk and just let all the alternates go because we never know what happened. But again, we want people to understand the gravity of this, and despite the discomfort, this is a very important situation for everyone involved.
And then the alternates will get to sit in here all day today and hear all the stuff today. And you'll be able to participate in deliberation. But does the defense have any wisdom they'd like to share?
I'm just kind of curious now, so I mean, I know that it is, I've already defended it once, so I'm assuming.
Really worried.
Yeah, right.
This, but obviously we have opening statements. Y'all put on proof. First of aggravators, mitigators, if you got any, you don't have to, but if you do. And then if y'all want to put on remote, you could. And then we do closed arguments. So I guess my question is, do you anticipate that we could get through this today enough to where I can get it to the jury? Or you think we just spend the night?
The state's aggravators, we believe, are proven in our case in chief, and we'll be putting on victim impact testimony. I believe with my conversations with the defense yesterday that they expect about a half day of proof for them. So I think it's plausible that we finish this today. It should be a matter of deliberation.
One short witness and then one family member that'll.
And then
She just kind of speaks deliberately, so it'll just take a little while to get through the family history. That's all.
So I guess though.
Maybe by lunch or right after, if you break in the middle of her testimony, I was thinking about this, because I think the court has been sympathetic to the juror's lunch schedule, whatever, and so you've been breaking in the middle of testimony, and I just foresaw being in the middle of hers and somehow lunch getting here. That's my only thing, it would drag into the afternoon, is what I'm trying to say.
Okay. See, rather if we didn't break for lunch, we'd really finish that witness. I want to do what you asked me to do.
I think it's just a matter of timing, you know, depending on how, I'm not trying to slam through her testimony, it's just depending on where we are in that, narrative.
And what would be your feeling if I told them, I want them, we're going to bring their dinner in tonight? He said, go back to the hotel. Or y'all have an objection if I get to that point and say, okay, if I get to the jury tonight, we'll bring a dinner in tonight.
I don't have an issue with that. I don't want to speculate on where the jurors' minds are, but I imagine they might want that too.
Right.
It's been a long, week-ish.
Okay.
But that's the other
Yes, sir. All right. So let's talk about, I think that the defendant has filed on 48 proposed jury instructions. I think I need to hear you argue each one of those. And as we go through each one, we'll stop and then let the state respond, and then we'll go through that one. Is that satisfactory? And I think the first one is your proposed charge into is the bench right not to testify.
Yes, Your Honor, come to the podium.
Would you be more comfortable sitting there?
I would.
Okay, sit there then.
Okay.
And y'all can sit there too. Okay. Go ahead, sir.
Judge, I think I have a similar, I'll just start by saying I think I have a similar bases for all of these in the sense that I have, to be honest, taken these from a source that is a useful handbook in my line of work, and I quoted what I think is appropriate constitutional and case law for most of these. Most of them are founded on federal and state constitutional principles. Some generally, some with case law citations, but I'm just going to speak generally as we go through these. And I would say that, not to get ahead of myself, but in the event I'm overruled, it would just be an Eighth Amendment objection across the board and 14th Amendment. So saying all that, we think it's appropriate that the jury be reminded that Mr. Finnegan does not have to testify at this case. And he's not making elocution either.
And if he chooses to, we have to have another moment. If he chooses not to testify or what, otherwise we still have to have another moment.
I agree.
Okay.
I agree.
All right. Can we go ahead and rule?
Oh, I'm sorry, Judge. Yes. Yes.
Do y'all have anything you want to add?
We don't have an objection to an instruction that he has a right not to testify, but we feel like the TPI is sufficient.
Right. And so what I'm going to do is I'm going to charge 43.03B, which I think covers the same, not the exact same language, but certainly covers the same issue. So I'm going to charge that, noting your objection. And so then let's go to number 2, aggravated circumstances.
And Judge, forgive me, but I did put a lot of these in just globally,
Sure.
and some of them are redundant. I will admit an overlap,
No problem.
just out of an abundance of caution.
We're good.
All right, thanks. So this is just an instruction on what the aggravating circumstances are and the presumption resulting from them, Judge.
All right. And I'll work on a draft charge for that. I may not use that exact same language, but I'll sort of cover that issue. I think it's an important issue. And then next is sentencing options.
Yes, Your Honor. I think that this jury is called at this stage to make one decision only, and I think I believe the court will, but I think they have the right to be instructed on what exactly this is. We talked about it ad nauseum, but these are the options.
All right. And I'll cover those options in my draft charge and show it to you as well. I too want to work on making it a little bit clearer so that they understand exactly what those options are. Next is the jury's ultimate responsibility.
Yes, Your Honor. This was in an attempt to prevent the state from somehow distancing them from their ultimate responsibility. In this case, if the state were to do that, I'm not saying they are, but we wanted it to be clear that the jury knows they are the ones making this decision.
What's the state's position on this?
The state believes this is an unnecessary instruction, and I think it will be clear, and especially for the TPI, it's their decision. That's why they're here.
All right. I kind of agree. I'm going to decline that request. Next is decision to be made by individual jurors.
Yes, Your Honor. Again, they work collectively, but I think it's important to remind them that each of them is a jury in themselves, and that they each have the right to make their own independent evaluation in sentencing.
Yeah, I agree with that, and I'm probably not going to use your exact instructions. I'm going to work on it, try to make it a little bit clearer. I'm not sure TPI is as clear on that as I'd like to make that, but I'm going to work on that for you. Then next is the.
I put maybe next to number 5. To be determined.
Maybe.
Yes.
I tell you, I'm not going to use your exact language.
I understand.
I'm headed down that path. 6 is aggravating factors considering statutory aggravation.
Yes, Your Honor. The state has, in their notice of intent to seek, Sentence of death has provided statutory aggravators. I have not seen any notice of non-statutory. So this may end up being the two.
I agree. Then next is aggravating circumstances definition.
Again, this may be redundant, Your Honor, but I think the court has its own instruction, but I just want to include it.
Right, and I think I'll use my own instruction in regard to that.
Yes, sir.
Next is weighing aggravation and mitigation.
Yes, Your Honor, this kind of breaks down the different weights relative to each side's burden, I suppose. Of course, we don't have a burden, but I think it's important for the jury to understand the kind of, it's almost like an extra burden in this sentencing phase and so I think this instruction encompasses that legal principle.
What's the state's position on that?
Again, we believe that the TPI is sufficient for the instructions, and they've been instructed ad nauseum from the time we were picking the jury that they had to consider mitigating and aggravating balances.
Yeah, I agree. I wouldn't deny that request. Number 9, defining aggravating and mitigating factors.
It's just a definitional section, and I'm sure there's an equivalent in the TPI, but I wanted to
There is,
include our version.
and I'll do the TPI one.
Yes, sir.
Then next is aggravating circumstances reasonable doubt definition.
Again, Your Honor, just an attempt to provide our own version of
Sure.
what we feel is the law.
And I'll probably do the TPI one on that, or reasonable doubt. Then next is burden of proof in aggravating circumstances.
Again, and apologies for redundancies, but nevertheless, we've got them all in here. And so I think, again, it relates to the sort of higher bar the state has in this space.
And I'll consider that, like I said, I'll probably fall back on the TPI instruction in regard to that. Then next is aggravated circumstances standards for consideration.
This is just to remind them that the aggravating circumstances alleged are just what they are. It's an allegation. I wouldn't even call it a criminal charge because it's not gone through grand jury. So it's just to reinforce that these are just allegations.
I'm going to deny that. I think that's already going to be in the charge. Next is presumption regarding aggravating circumstances.
Again, this relates to number 12, a little different, but it's to remind the jury that that these are not proven unless and until they find that they've been proven.
And what's the state's position on that?
Again, we believe that TPI is sufficient and the instructions as they exist are sufficient.
I agree. I'm going to decline number 13. 14, aggravating circumstances, unanimity.
I think it speaks for itself, Judge. We just request the inclusion of some instruction as to unanimity.
Yeah, it's a correct charge, but I'll add a similar charge to my jury instructions. Aggravating individual consideration or requirement of unanimity.
I know it's that word.
Right, I almost got it. Go ahead.
Anyway, this again reinforces we believe that they have to be unanimous to find aggravating circumstances, but that they should exercise their own independent judgment.
And I think that's already in the TPI charge, but I'll make sure that area is covered. Then next is first degree murder is not an aggravating circumstance.
I think that's been rendered moot by the verdict.
I agree. Then next, 17, felony murder not automatically an aggravating circumstance.
So I think if I had any, well, I'll get to the ones I really think are most important, but I think this one is very important in this matter to explain to them that just because he's been convicted twice of felony murder, that itself is not proof of an aggravating circumstance.
And what's the state's position on that?
Your Honor, please, it is an articulated aggravating circumstance that we filed notice for. Believe that we were able to argue that. I don't think there's anything that is automatic. So we certainly have to prove that they found him guilty of these, and now we have to tell them that they weigh whether that is an aggravating circumstance. I think this is muddying the waters. Really.
I agree. I'm going to decline that request. Number 18, crime in society.
This is just to, these are more defensive instructions to prevent or preclude the state from arguing about this theory. That's
Sure. don't argue crime in society, but I'm going to deny that request unless y'all argue it, and then they can bring it up. Next is deterrence cost.
In a similar vein, Judge, is to preclude the state from arguing that factor.
I'm going to decline that unless they bring that up in the argument. Then next, mitigation reason for sentence less than death.
And this is really just kind of a heading instruction where we just, we add in our list of statutory and non-statutory mitigators that we file.
I'm going to decline that one. Then next, mitigation definition, weight, and unanimity.
Yes, Your Honor, this is just our proposal.
It's kind of a combination, kind of bring it all together.
Yes.
Right? Okay. I think I've already got that in the charge, so I'm going to decline it in this form as you suggest, but you need to review what I say about it
Yes,
in the charge that we do. Let's see. Mitigation, standard of proof. I think that's a correct statement, so I'm going to do that one.
thank you.
Number 23, mitigation cannot be considered as aggravation.
I think that's important. Again, I don't think there's going to be extensive proof in sentencing, but I think it's important to remind the jury that even if there's other bad things that are brought out in my client's mitigation phase or the presentation, that should not be considered as an aggravation.
Okay. I'm going to deny that request. Next, general closing instruction, sentencing phase. And basically, you've got kind of the same language as in TPI, it just kind of expands it.
It does.
Well,
It does, Judge.
I'm probably going to deny that as well. You can review the one that I'm going to send to you.
Yes, Your Honor.
And then let's see. Then 25, doubt endures to the benefit of the defendant. Tell me about that, because I already charged reasonable doubt. Tell me why I need to do this.
I'm satisfied with reasonable doubt and explanation, Judge. I will
And then, I'm interested in 26 in mercy.
I think a jury, I think in mitigation, the jury is permitted to, as long as it's based on the evidence, to consider, to make their own individual decision. And I think that's just to remind them that this phase is different than guilt and innocence, and that they can rely on their own morality and sense of mercy in reaching their decision.
What do y'all say about applying mercy?
TPI is sufficient, and we believe that they can make, they have a wide breadth of what arguments they can make and mitigation factors.
So they can argue for mercy.
I think they're probably permitted to do that, but I don't believe it needs to be an instruction.
Okay, I'll review the instructions, see if I'm satisfied with how I covered it. And then next, consideration for sentence less than death.
I think this is a continuation of 26, it just expands it, and so
That's exactly right, that's exactly what I wrote down.
I-
So, I think I covered it 26, 28, 29, 30, 32.
And
So
again, Judge, as I said in my intro, I think some of these may overlap, turning to a Venn diagram.
And I think that same thing applies on 28 as well.
Yes, and 29,
And 29 is, you're asking about sympathy, so that's kind of the non-statutory mitigator that kind of catch-all covers that.
yes,
I mean, I use those exact words, but I'll cover that in my instructions as well. Then the next one, I think we've already done that, mitigation.
sorry, didn't mean to interrupt you, Judge. I think this again is related to the general mitigation.
Right. Then 31, I think it's already in the charge, I just kind of use different language.
Okay.
Let's see. 32, so I guess my question is, are y'all asking for mercy as a non-statutory mitigator? Or are you just going to argue it?
I think I'm just gonna argue.
Okay? So I will now list it as a non-statutory mitigator. Then next, finding beyond a reasonable doubt that death is appropriate. I think that's already in the charge, but I'll review it to make sure it is. And you can look and see my work as well, see if it's okay. And then, this fairness or proportionality, are you just gonna argue that, or is that gonna be a non-statutory mitigator?
I think based on the verdict, it absolutely should be a non-statutory mitigated. And I would be arguing it as well. I think this is a cornerstone of my argument today based on the verdict.
Okay, I'll take a look at that, consider that. And next is, residual and lingering doubt. I think you listed that as a mitigator.
Yes, Your Honor, and I think I would like this included. I think perhaps it has less relevance based on the premeditated verdict and the not guilty on the conspiracy to commit first-degree murder, but I still think it is appropriate because we're dealing with two people, two actors in the same event. So I think
If I did that and you listed as a mitigator and can argue as a mitigator, am I not giving it a kind of a boost or a supercharge if then in addition to you arguing it as a mitigator and I charge it as a mitigator, then I give an instruction on it?
I just respectfully ask for
Okay,
whatever.
okay, I'll consider that.
we can
And
get.
then, inability to agree.
I think it's probably covered somewhere in the TPI, but I just wanted to make sure it was considered that they were given instruction on what to do.
Right. So that was, I think that was 48, if I remember correctly.
Yes.
And then tell me on 49, what you want me to do.
Yes, sir. Yeah, just a second. Judge, our motion limiting 49 deals with the state's notice, deals with the state's notice of intent to seek death. The state has alleged in their notice 6 statutory aggravating circumstances. And specifically, this motion addresses the felony murder aggravating circumstances, which the state has listed as 7A and 7B. And based on my review of the statute and the case law that's related to this, we believe it's inappropriate for them to be able to consider that twice. And we think they can say it relates to 2 different charges. That's fine. But we think it's only appropriate for the jury to consider one single aggravating circumstance as it relates to a string of felonies committed in perpetration.
All right, so you're saying that instead of arguing both felony murder on kidnapping and felony murder on rape, that they should just consider felony murder. Is that right?
I think so. Or at least included in, I just don't want, I think it's kind of, I think it inflates. Inappropriately.
Right.
Yes.
Okay. What's the state's position on that?
State's position is, of course, I believe the state of the law is that it can only be considered once, but this, we would combine that, say this is one aggravating circumstance that applies to kidnapping and rape and felony murder context.
Okay. I'll work on that. Let's see. And then the last thing I think was number 50, and that's just where you'll filed your notice of mitigating circumstances.
It is, and unfortunately, I filed that first, and I realized I'd skipped 2 numbers, and so it turns out I had 2 other motions to file, so I think everything is correct sequentially. But yes, that's our notice.
All right. And then, yes, does they respond to their mitigators?
No,
And then I've got some impact letters. Have y'all seen these? Have y'all reviewed them?
We have,
Are there areas? Go ahead.
we do have a family member who has added a paragraph that we have just received, and of course, we'd like to proffer that in front of the court.
Sure. And I'll look at.
we'll make it, you want to make a copy for you, Judge?
That'd be great.
Additionally, they're telling me that Jennifer's grandmother who raised her, she's elderly, but she does want to make a statement, and that's on its way, so.
So is the grandmother going to be here? It's like,
Yes, no, she's gonna be here today.
okay. All right, so I'll have to,
As soon as we get that, we'll forward it to the court. The court's
but
consideration.
the one that's got the added paragraph,
Can I hand you the original, Judge, up there so you can read the added paragraph and
why
decide?
don't we just get a copy of the thing?
Okay,
And then I'll look through it. And then before I bring the jury back, we'll go through the initial paragraph on the record, and hopefully by then the grandmother will be here and she can read hers.
yes, what time was she?
They were on their way, there's one, there was an accident.
Okay, good.
Thank you.
I'll do that. And then if y'all reviewed it, if there's lines in here that y'all have objections to, if you could just give me a copy that highlighted what you had objections to, then that way I can look at it. There were a couple of lines I need to take out from the last lady that read hers that I haven't done yet, but I'll take those out.
And I think that's appropriate. We don't have any other objections to it.
Okay.
We think the court has moderated that
Okay.
sufficiently.
All right.
Notwithstanding whatever.
All right, what the other one says, sure. Okay, anything else from the state you take care of? Anything else from the defense? So probably if the jury gets back here at 10, I may go ahead and take care of no, you should not do that. You should take care of the 12 jurors first. Right, and then take care of the audience. Okay, so I'll bring the 12 jurors in first, just check on their general health and well-being. And then I'll let them go back, then I'm going to bring the 2 alternates here, have a little visit with them, and then make some decisions based upon their is that okay?
Yes, Your Honor.
Okay, all right, thank y'all very much. And so we'll start back at, operating 10. Thank you.